We'll be done for 6 anyway, Belmere. Fan up.
Okay.
By now.
We're live, ladies and gents, please. Right, ladies and gents, first of all, good evening and thank you all for attending tonight's Licensing Committee, Thursday, 18th of March, 2020. First of all, is there any apologies?
I've got apologies for Councillor Smale.
Thank you for that. Councillor Holmes. Any more apologies? Okay, brilliant. Any late items to be introduced by the Chair? None by me. Item number 3, any declarations of interest? I'll take that as a no. Item number 4, minutes of the mass meeting held on the 20th of January 2021.
Move them, Chair, as an accurate record.
I'll second that, Chair, as well.
Thank you, Councillor Skelton. Councillor Marshall. Just before we move forward, Angela, if I can ask you to come in, can you just give us a quick update on the impact that the COVID has had on the trade that was minuted in the last meeting, please?
Yes, of course, Chair.
Thank you.
We did suggest last time that we would be able to bring that report to this meeting, but unfortunately I think that was a little bit optimistic due to the time and the amount of knowledge we've got at the moment about the impact of COVID. And insofar as the regulatory trades are concerned, that actual impact might not be seen until a little while after the city opens up again. And as we start getting people back into the city, as businesses start to operate a little bit more towards the normal side.
Yep.
So over the next couple of months, it's planned that I liaise with some of our other teams that have been dealing with the COVID responses within our service, and if we can get any input from those around us, and hope to bring something to you that should give us a little bit of light provisionally for the provisional July committee. I think the first one is, if that's acceptable, Chair.
Yeah, that's fine by me. Yeah, no, thanks for that. I appreciate obviously difficult times, and obviously we can only work with what we've got, so a little more time is needed. If that's the case, then so be. But no, I thank you for that, and I appreciate the update. Right, I'll go on to item 5, the Equality Act, provisions of wheelchair accessible vehicle list. I think that's back to you again, Angela.
It is, yes, thank you, Chair. Hello, everybody. This portion that I'm bringing to you now is an item that has been brought to us through the Equality Act 2010. Now, that Act itself's been around for quite a long while, but it has been released in parts and at different times. The area for the purpose of today's report is included in Chapter 1 and specifically called Disabled People and Transport, and the sections I'm using out of that are going to be between 165 and 167. They're the 3 sections that relate specifically to our licensed trades. As a council, we obviously have a responsibility to ensure that the city and the services we provide are accessible as far as we can to everybody, and that includes the transport services. In general, I think wheelchair users can sometimes feel less confident in visiting places if they don't have the information to hand about what transport is available for them to use. And whilst I know we've got very good networks of buses and trains, some passengers may require a more individual service, particularly if they require help getting in or out of a vehicle or require to stay in their wheelchair whilst travelling. An option we have here is to use the power of the Equality Act and introduce a wheelchair accessible vehicles list so that disabled people have that additional information open to them. Disabled groups and networks nationwide have requested that licensing authorities use this list, and this report is also supported, sorry, not this report, but the element is also supported by the Department of Transport, who have kindly issued us some statutory guidance, and they are requesting that licensing authorities do have this designated list. As a brief overview, through the sections of the Equality Act introduced in 2017, the government allows a council to create a list of wheelchair accessible vehicles. These are vehicles which are capable of carrying passengers in wheelchairs safely. We are in a very good place as all of our Hackney carriages are able to carry what's termed as a reference wheelchair with its user secured properly. Obviously, there are limitations as to size, as some of the motorised wheelchairs can be very large, and in those circumstances, special vehicles are usually required. Drivers' responsibilities under the Act are to carry the passenger while they're in the wheelchair, not make any additional charge for doing so, take such steps as necessary to ensure passenger safety, and give the passenger mobility assistance where reasonably required. The Act is quite specific in its definition of mobility assistance, and that is that assistance to enable the passenger to get in or out of the vehicle. If the passenger wishes to remain in the wheelchair, to enable the passenger to get in and out of the vehicle whilst in the wheelchair, and to load the wheelchair in the vehicle if the passenger does not wish to travel in the chair. Now, they're all the duties that we would normally expect drivers to carry out for their passengers. Excuse me. But obviously, in some cases, that doesn't happen. But this list will just give the people that want to travel that bit of security. Before we can publish the list, drivers need to be given notice that we are going to put their vehicles on the website and that those vehicles will be available specifically for this type of use. Drivers can request to be made exempt from those requirements if they feel that they cannot assist passengers in the way that these requirements need them to, and that has to be on medical grounds. We already have a mechanism in place for this, and any exemption will remain in place for the life of the licence. Now, that would be no longer than 3 years. Once the period has elapsed for applications for exemption, the list will be made live, and unless exempt, it will be an offence for drivers not to comply with the requirements of this part of the Equality Act. The list will contain the make and model of the vehicle, whether it's a Hackney carriage or private hire, and state the name of the operator or proprietor. In summary, Chair, the recommendation today is for this committee to agree the implementation of the wheelchair accessible vehicle list in accordance with those sections of the Equality Act. And I can confirm that our own disabled persons group representatives have seen this report and have also requested that we implement the list. Thank you, Chair.
Okay, thank you very much for that, Angela. I've got a couple of questions. First, it's Councillor Khan, and then after that.
Thank you. I just want to ask regarding the training. So is training in place for drivers that will be carrying the having disabled access for their service users or clients? And also, private hire, you said. Did you say private hire also? Is it just Hackneys?
I will clarify that, Chair. Firstly, in relation to the vehicles, all our Hackneys are already wheelchair accessible. So the drivers who already take out these vehicles should be fully trained in how to load and secure a passenger in their vehicle. So I wouldn't envisage there would be any training needed for existing drivers. In relation to Hackney, to private hire vehicles, I do believe that there are the odd one or two that are assigned to operators, private hire operators. I'm just waiting for clarification of that to come back, because if those two vehicles are licensed by us, then they as well will be going on to the 157 list.
Does that answer your question, Councillor Khan?
No, I think my question also is that the ongoing training, because obviously wheelchairs and health and safety and all that training has to be monitored. Yeah, and I think that there should be a continued training for drivers also.
As I alluded to, Councillor, the drivers to be fit and proper and be able to drive a Hackney carriage, because of the type of vehicle they're driving, are responsible for loading and securing their passengers.
Okay.
So they should already be trained in that element.
If I'm not wrong, Angela, isn't that part of the NVQ that they take out?
It is part of some of the training that they do, yes. And there are companies out there that will, if a driver does feel that they aren't quite comfortable enough with their training, then there are companies out there that may well provide those additional training elements for them.
Okay, thanks for the clarification. Next question is Councillor Alison Holmes. Over to you.
Thank you, Chair. Can I just ask a question, Angela, of 4.5, where it says allows licensing authorities to exempt drivers, blah, blah. Do we accept Hackney drivers with permanent exemptions, considering that they are the vehicle that takes wheelchairs? I'm probably not making myself clear here.
I think I know where you're going, Councillor. I can confirm that yes, all drivers that we have are obviously considered fit and proper, but under certain circumstances and for medical reasons, it may be that a driver, as an instance, may have a medical back problem that means he may not be able to physically push the wheelchair into a vehicle. However, some wheelchair users like to put themselves into a vehicle. So we wouldn't bar a driver, a person from being a driver purely because they need this exemption, and that's what this exemption is for, purely to release them from the responsibilities of a driver under this Act, under the Equality Act, and they will have to display a badge to say that they alone cannot physically carry out those duties, whether it's moving the wheelchair or carrying luggage. It's very similar to the exemption that we have for carrying guide dogs or assistance dogs.
Thank you. So currently, though, do we not issue temporary exemption? Say for somebody who has, just like you've just said, like a back injury, and if they come with a doctor's certificate, we allow them to have an exemption. So it's not a permanent for the life of the licence exemption. It's just temporary until the injury is repaired. So what would happen in those circumstances?
If there was only a short period of time where the exemption may be required, the legislation allows us to make that exemption can be done up to 3 years. I think my point on that was the fact that that would be the maximum if someone had an ongoing long-term medical problem. It may be that they just renewed their licence for 3 years, so their exemption would be for 3 years. But if somebody's licence was running out, say they got an exemption and it was running out in a couple of weeks' time or a couple of months' time or 6 months' time, then we may ask for an exemption again if they come it was only a short-term illness. That's why we report back up, so that we can actually see what the doctor, what the medical expert is advising. Does that help?
Yeah. Okay. So you would have to possibly then, if you had a list, you'd possibly have to. Would you have to amend the list accordingly when people were off and on, or would it just?
No, we would make sure that we would list in once a month, the driver's record would be noted, so that if he got a 6-month extension on the, say, the 5th month, they would be reminded that we'll be running out on so and so.
Okay, thank you.
Thank you for that clarification. Councillor Peatfield, your next question, please.
Thank you, Chair. A couple of questions, and I'll try and squash them into one sentence. The bigger electric wheelchairs that aren't the reference wheelchair size, how many cabs have we got that will fit those? Are they also listed separately so that people with electric wheelchairs are aware as well? Are we doing more than the minimum that the Equalities Act requires? And are there any recommendations from the Equalities Board?
Okay, just bear with me. The first part was some vehicles, I couldn't tell you which ones offhand, but there may be the odd hackney carriage, as we're moving over to the newer vehicles, that is, that will be able to carry a slightly larger vehicle, wheelchair. But as you can probably appreciate, some of those motorised wheelchairs are extreme in size, and so would require maybe even a PSV vehicle to help them with their transportation. And usually when a user is in, shall we say, a larger type wheelchair, then we usually find that they are aligned to their own carrier anyway, because of the purpose of the carrying. But like I say, from what I've seen, when I've looked at the brand new wheelchair accessible vehicles, some of them are quite high for accessibility and a bit wider for accessibility. So some may fit, I think, is the answer, and some may not.
So we don't have an actual idea of how many we've got, and so therefore we can't list them?
No, the Department of Transport takes us as far as using this for up to reference wheelchairs.
Well, that takes.
So that is a standard size wheelchair, not the overly big motorised wheelchairs.
So then that takes me to the second part of my question, really, which is that are we doing more than the minimum? Because if we could quantify how many of our vehicles will fit just a slightly larger wheelchair, then surely we could list that and it would be of help.
We could have a look at that and see if we do hold that information, because that would be down to the specification of each vehicle, a little like when you or I use a vehicle. It would mean going through every single vehicle just to check whether that would apply. So in the first instance, this report is to get the main information out there, and there's no reason later on why we can't look to see if we can enhance that list and make it even more user friendly.
Okay, thank you. Could that be minuted as something that we will definitely look at, and could you perhaps feed back to us at a later date?
Yep.
And then the last bit was just about, you said you spoke to the Equalities Board. I mean, there's not an assessment with this, so were there any further recommendations that aren't in the report that we could look at?
I actually sent this report and the background information to our Equalities group, and they sent it back with their comments, which have been included in this, and then a paragraph to say that they support this report as it stands.
Oh, okay. I've not seen the full report attached. Okay, thank you.
Thank you, Councillor Peatfield. Is there any more questions from anybody? Okay, before we go on to item 6, just a quick warm welcome tonight to Samantha Dennis, who's the new Director of Public Protection and Street Pride. Thanks for joining us tonight, Samantha, much appreciated.
Thank you, Chair.
Right, over to item number 6, the Gambling Act. Michael, that's over to you.
Sorry, yes, sorry. You just need to formally, because there will vote on the recommendation.
Yes, everybody, Everybody for the recommendation?
Yeah. Oh, good.
Yeah. Anybody against?
Yes.
Okay, that's carried. Thank you for that, Olive. Right, item number 6, the Gambling Act Statement of Principles and Consultation. Over to you, Michael.
Yeah, thank you, Chair. So as set out in the Gambling Act 2005, the Council is required to prepare, consult and publish what we call a Statement of Principles, which sets out how it will exercise its functions under the Act. The Statement of Principles was first published in October 2006 and it's required to be reviewed every 3 years. The last review was undertaken back in 2018. So before determining or revising the content of the Statement of Principles, the authority must consult widely on its draft proposals. And a revised draft Statement of Principles is set out at Appendix 1 for committee's consideration. Now, there is some statutory guidance that runs alongside the Gambling Act, and in that guidance it talks about, you know, the requirements that need to be set out in a Statement of Principles. So in many respects it needs to be very prescriptive, the Statement of Principles that that is produced. So because it's been in place for a while now, you know, we have sort of honed the information that's set out in the Statement of Principles to align it with the statutory guidance. So the amendments that we have made to this particular draft version are really very minor, Chair, and as such it's proposed that the document undergoes an 8-week consultation period to enable any comments to be received. Responses to the consultation will be considered and referred to Licensing Committee at a future meeting to agree the final version. That will then need to be subsequently referred to full Council for ratification. As we speak, the Gambling Commission are looking at some proposed legislative changes, and when the outcome of that process is known, it may well be that we have to insert some of those changes that have been made into the final version of the Statement of Principles, and that may actually happen after we have the consultation period and that closes. It's not a major issue because as they are legislative changes, they have to be incorporated into the Statement of Principles regardless of any consultation that takes place. So if that happens, we will make sure that those legislative changes are included in a final draft version that we bring back to committee. The final revised Statement of Principles should be published by the end of December 2021, so we have got some time. It needs to come into effect before the 31st of January 2022. The recommendation, Chair, is to approve the draft Statement of Principles that's set out in Appendix 1 for release for consultation. Thank you.
Okay, has anybody got any questions? Okay, and are we all in favour of the recommendation?
Sorry, I'm a bit slow.
Go on,
toggling between different things.
Go on, carry on.
I just wondered if we've looked at the whole thing of fixed odds betting machines in one-arm bandits basically in our betting shops. Because as we know, this can be a terrible thing for gamblers, and particularly if you have children in the family, and the children go without because the gambler has spent all the family money basically. And I think it's a generally good principle that we reduce the number of fixed odd betting terminals that are available, and also the range of how the betting shop owner or manager supervises the fact that if they see someone is obviously addicted, that needs to be looked at, and they can be barred from that. I know they can go elsewhere, but they can be barred from that machine. I don't know. I couldn't see. I really quickly looked through, and I couldn't see anything about fixed odd betting terminals, FOBTs.
Yeah, I mean, as you say, Councillor Hazelgrave, it is something that has received a lot of press, hasn't it? Over, it's probably not so recent. It was a while ago now, and I know it's part and parcel of what the Gambling Commission are will look at and will control, because the Gambling Commission has a role to play in overseeing that process too. So as I said in the presentation, we are quite limited in terms of what we can include in our statement of principles, because the statutory guidance that the Gambling Commission produce set out those parameters that we need to incorporate into our document. And as I said, if there are any legislative changes, and that would apply to fixed odd betting terminals as well, that the Gambling Commission's review sort of comes up with, then we will certainly include those in the statement of principles that we will bring to licensing committee at some point later on in the year.
And just as a further thing, do we actually grant licenses to managers of betting shops? Does the city council do that, or is it not a power that we have?
No, not. And Angela may be able to clarify for me. Not in relation to the individuals that run them. I'm not aware that that's the case. It's not like personal licenses for alcohol.
No,
Chair, yes,
Sorry.
I can probably help there, Chair. The Gambling Act powers, so far as local authorities are concerned, are primarily directed towards the premises, not the individual who manages it. My understanding is that that's fundamentally the preserve of the Gambling Commission.
Yes, the Gambling Commission will issue the personal licenses,
right,
for the managers, the operators and the companies.
I'm just wondering how managers are kind of supervised in terms of how they do apply their powers to, to stop someone from using the machines when they clearly are addicted, and it's actually harmful for them to be doing it for them and their family.
I think that's.
Do we have any power over that?
I don't think we have any power over that. I mean, that's a bit of a double-edged sword, Councillor. These managers want people to come and then spend money.
Absolutely.
So it's a tricky one. It's a very, very double-edged sword. So yeah, I get where you're coming from. I think, but realistically, I think we're powerless, and that's just where we are with it.
Yeah. Oh well.
I think, Chair, the only overlap between the individual licenses issued by the Gambling Commission and the premises licenses which we issue is that if an application for a premises license is made by someone who has previously had their individual license rescinded or revoked or anything of that nature, then we can say no to the grant of the premises license. But in terms of the enforcement, sanctions against the individual, all that is really within the preserve of the Gambling Commission.
Thank you.
We have something we can do then. It's not the best, but we've got something.
Yeah. Question, Councillor Holmes, would you like to ask a question?
Sorry, I was just going to chip in on what Councillor Hazelgrave was saying. The fixed odds terminals in betting offices, they've had their stake reduced to £2, and as far as I can remember, it was about 2018 when that happened. So I mean, I've got an interest because my dad used to be a betting bookmaker. Sorry. So that's already been done, 2018. Reducing the stakes to £2. So, and I think that it is, what's the word? They are inspected, yeah, by the Gambling Commission.
Okay, thank you for that, Councillor Holmes. Any more questions from anybody? Are we all in agreement for the recommendations?
Yeah.
Yes,
Yeah.
Chair.
Okay.
Yeah.
Thank you, Councillor
Yes, Chair.
Sandu.
Yeah.
Thank you. Okay, thank you for that. Item number 7, statutory taxi and private hire vehicle standards update. Angela, I think that's over to you.
Thank you, Chair. Again, I'm sure you'll be aware of this subject. I think it's this is the second main update I've been able to bring to you since the first introduction of it to you last year. Last time we met, I'd been able to look through the content in a little bit more depth and highlight what we were already doing and what we were doing well, and that was quite a lot. As I've explained before, we are well ahead of the game in a number of the areas mentioned in the document, and as you know, following publication of the very damning J report in 2014 and Casey report in 2016, we introduced many more safeguarding measures. We're not a council to sit back though, and continuous improvement reviews are always taking place, licensing not being exempt from that. So we now need to focus on areas which could be reviewed, and in Appendix 1 to the report I've summarised a basic timeline for the work planned to be undertaken over the next 12 months. Obviously some of these subjects will cross over, so the timelines are a little fluid. If we look at the short-term elements, some of the short-term work involves looking at our existing application processes and seeing if they can be streamlined safely. This sort of review can be carried out and implemented relatively quickly, particularly with things like your driver, operator and vehicle licensing applications and the renewal procedures. These things are administrative and should not therefore require any consultation. Conditions for each type of licence will also be revisited. Over the last 12 months, everyone has had to become more familiar with technology, and taking advantage of that, we'll be looking to move more of our processes onto a more digital platform. This will help streamline processes and should help reduce any delays when dealing with customer applications, and also give the customer some control over their own application progress. The training requirements such as safeguarding and knowledge testing will also be reviewed, just to make sure that they capture today's emerging trends, those such as county lines and trafficking. There are new things coming to light all the time, so to keep in front is always a benefit. And it may also be possible to move these online too. On the subject of training, the statutory standards document is specific in the importance of councillor and officer training, and that's to ensure that everyone is as up to date as possible and are well equipped to make the decisions that they are required to deliver. I will hopefully be working with our councillor development team and legal to provide some options for additional training. The minimum training for members will include such things as licensing procedures, the course of natural justice, understanding CSE, disability and equality, the making of difficult and potentially controversial decisions, and the appearance of bias. I can only stress again that attending these training sessions is extremely important. If a decision goes to appeal, it will be one of the things that may well be considered. I'll also be looking at our delegations at some stage, just to ensure that there's a clear separation between the responsibilities of the enforcers and the decision makers. Now, although there seems quite a lot in there, that I think those things can move forward pretty quickly. So I'm hoping by the end of May that we should be able to move forward on those quite well. Next, we move into the medium-term themes, and one of these, or the whole of this area, seems to centre around information sharing. That's whether it's with other authorities, I'm talking locally and regionally, with partner agencies, commercial enterprises, taxi watchers, taxi trades. There's a lot of people out there that can work together to try and make all this work safely. The more information safely shared, and I stress that safely shared, between stakeholders can only strengthen our objective of public protection. This can sometimes be a little bit more protracted, which is why I've dropped it into the medium. We usually have to start work on some information sharing agreements, and they need developing, then they need agreeing, and then they need signing off. So that can take a little time sometimes, especially when you've got different partners. We already have some very good partnership groups in place, so without reinventing the wheel, we'll start there using those contacts and those groups. There's some really good people in there. And maybe setting up some subgroups of, say, decision makers and operational, so that those elements can be dealt with separately, because obviously there's going to be different issues with different areas. And again, that could be locally or even regionally. If we can get some consistency regionally, that would be absolutely fantastic. Part of the information sharing element is a product developed by the National Anti-Fraud Network after being commissioned by the LGA. It's called NR3, and that's the National Register of Revocation and Refusals. And this allows a licensing authority to check if an applicant has had a licence revoked or refused elsewhere. Without being able to check this, a person may easily obtain a new licence in another area without that area knowing that they'd held a licence before and had it revoked. And that's something which could undermine public safety, which obviously we don't want to do. The more licensing authorities that use it, obviously the stronger the tool will become. And since its launch in 2018, 23% of licensing authorities have signed up to it. So that's part of the work I am starting now on that information collection project. We do carry out joint operations with the police already. So again, we have those contacts there. And so we can build those relationships and talk about more information sharing. But again, with the police, information sharing agreements are important. Our current enforcement policies have been in place for quite a while now. They are due for an overhaul. This will be quite a big piece of work as well. It will require consultation, so that's why it will take a little while longer, and obviously we'll be coming to you probably several times over the year. Using those partnerships mentioned, it's hoped that we can move forward with the creation of a cross-border enforcement protocol. Again, this is a regional piece of work which would help local authorities help local authorities. Again, the similarities between processes, practices and enforcement is a strong tool. As we move towards the long term, you can see from that short and medium, there's a lot of work going on there. And as I mentioned earlier, it's the power of our policies and practices that make us where we are, that put us where we are now in a very, very strong position. And in making sure that they're fit for the purpose will carry us forward as well. And to make sure that they do that, we do need to review on a regular basis. So at the beginning of 2022 is the ideal time to step back, reevaluate what we've done, collect our thoughts together and forward plan for the next 12 months. As the short and medium term projects will be well on their way to completion, the work in relation to making the website more user-friendly will begin. I know that there is already some work taking place corporately who are doing a website overhaul, and this will help tie in with the plans for licensing to become basically digital by default. Hopefully easy to find, easy to use, so the information that a customer will want to set up their small business legally will all be there at the click of a button. That's this report for mention, Chair.
Thank you very much for that. And before I take any questions, first of all, thanks for a great report, and it's heartening to know that we're actually on top of everything, and we're moving in the right direction with the support of this committee, and everything's in place. So no, thank you for a great report. My appreciation for that. Over to you, Councillor Peatfield next, please. Your question.
Thank you, Chair. I don't know if it's just me, but at 4.11 it says it refers to Appendix 1, but I don't have an appendix attached to this item. So I can't.
It should be mine's. If you scroll right down to the bottom of the page, mine's on there. If you carry on scrolling right down to the bottom.
No, it only goes to page 4. So yeah, I just wonder if that could be shared, please.
Yeah, could that be sent out, please?
Yes, of course.
Okay. Was that it, Councillor Peatfield?
Yes, thank you.
Thank you. Councillor Holmes, question for yourself?
Hi, thank you. Where am I? So, you know, you mentioned, Angela, the training undertaken by members.
Yes.
Can I assume that we will then be going back to a day training session and not the short sessions that we have been having in previous couple of years? Is that a plan?
I think that is something that would go into the melting pot for training, because obviously, as you and the committee are aware, we have some very complicated areas of licensing, and so to fit all that in a short period of time is not giving you the full benefit of that training and that support. So it may mean that, yes, we would look at whether it's half day or full day on specific elements of training. So different areas, maybe a gambling, maybe a licensing, maybe a regulatory, and then maybe a taxi. It may be something like that that we could work forward with. And it might not all be external training. There's a lot of training we can do in-house, but I think you would definitely benefit by a longer training session.
Thank you. I only ask because it's been brought up today, because I attended the training day that was on offer for us today, and it ran from 9:30 till 4:30, and it was extremely informative. And I know we used to run the training days. You won't know, Angela, but Mike will. And I mean, I have complained the last couple of years that it's too short, especially for new members, and especially for the fact that the legislation is changing so quickly and so often. It was really informative. So it would be great if we could try and get that training day back. Is my first thing. Secondly, the NR3 database. There was a lot. I attended the LGA well, I didn't attend. I was sitting on my settee, but you know what I mean. The LGA conference, and the NR3 database was literally their way forward, and I totally agree. Without that, we cannot stop all this multi, cross-border stuff taking place that none of us like, and that we can't legislate. So I'd like to push for that as soon as possible, if that's at all possible. The third thing was, in the government paper, it said there was a big section on educating the public for how, making it easier for the public to complain, how to complain, who to complain to, better signage, things like that. Where would that be looked at in this list?
That, councillor, it'll probably be a mix of them both, because as we're changing procedures and practices, obviously that will need to be relayed to the people themselves. We are, again, very lucky in Derby that we do have a corporate system for making complaints, and we do have a website which points a person to licensing for any specific complaints that they want to take further. But yes, that is something that we'll be looking at it would probably fall, like I say, between the short and the medium, but the actual notice on website, that will probably change towards the medium element in the information sharing theme.
Okay, thank you.
Thank you, Angela. Has anybody else got any more questions? Okay, I think then that concludes tonight's meeting. Thank you all for attending, and have a great weekend.
Okay, thank you. Bye bye.
Thank you. Chair. Cheers.
Thank you.
Night.